2021. We ended the last session on a high note about a new hope, mediation, therapeutic justice. This session is about all the world's a stage in advocacy. Are you hearing what you're saying? Will it be the Empire Strikes Back when it all gets into court? This session will see the same couple in session 5 eventually having to resolve their disputes in court. Once again, the panelists will draw a distinction between TJ and non-TJ minded approaches and behaviors and demonstrate how, in spite of what may be perceived as an adversarial system, practitioners can display the former TJ through various stages of litigation, including preparing their clients for court hearings, communicating with counterparts, and advocating for their clients in a courtroom. Together with session 5, this session aims to shed light on how practitioners can better practice through a TJ lens and offer a glimpse into Singapore's upcoming TJ certification training. Your panelists for this session are Judge Suzanne Chin, District Judge, Family Justice Courts; Sophia Ang, Senior Director, Counselling and Psychological Services of the Family Justice Courts; Harry Gill, Partner, Harry Elias Partnerships LLP; Professor Dr. Vikki Lenz, Hunter College, City University of New York; and Poonam Merchandani, Partner, Merchandani and Partners. The panel will be moderated by Judge Ken Yap, Registrar, Family Justice Courts. Now, a reminder to all our delegates here, questions regarding this session can be submitted through the MicePad platform Q&A functions. Ladies and gentlemen, your panel.
Well, thank you very much, Darren. First of all, I hope that we can skip the Empire Strikes Back and jump straight to the episode A New Hope. Good morning, everybody. Let me say what a privilege it is to join you here today. May I extend my thanks to the two FLPC co-chairs, Kai Yun and Lilian, as well as their team for the excellent work they've done in putting together this conference. Now, today we are looking at advocacy through the lens of TJ, which has been at the front and center of family justice discourse over the past year. Now, this is so much so that it's already become fashionable for litigants and lawyers alike to invoke the name of TJ in hearings to advance their respective causes, even if such causes turn out to be diametrically opposed. Now, this is the lip service that Kanya spoke of earlier. Now, like the proverbial three blind men and the elephant, we all know TJ is the elephant in the room. We all agree that it should be there, but when we try to drill down and articulate its meaning, we often find ourselves describing only certain parts and not the whole. What we do know is that TJ is not a convenient tagline for doing more of the same. It is not simply about the court sending parties for more mediation, more counseling, or more therapy. The objective must surely be a broader, more holistic one, where all players are required to focus on solutions rather than rights and liabilities. And this, as you have seen from the video clips, may be difficult if one party is solely focused on winning and losing, rather than working together to manage conflict and to effectively co-parent. Now, as you have heard from our presiding judge this morning, the FJC has already been testing out some TJ ideas and practices in our multidisciplinary team pilot. Now, today we are excited to broaden this conversation as part of our effort to develop a common language of TJ and to set clear principles of engagement between judges, lawyers, clients, and social service professionals. It's my pleasure to once again welcome our distinguished panelists for this session. First, Dr. Vikki Lenz. She really needs no further introduction. As you know, she's the professor at the Silverman School of Social Work at Hunter College of the City University of New York. Now, Vikki comes armed with dual degrees in social work and law and has worked closely with FJC on the development of our TJ doctrine. So we are most excited to glean her insights. Next, we have Dr. DJ Suzanne Chin, one of our most senior and experienced judges at the FJC. We also have with us Ms. Sophia Ang, who leads FJC's in-house team of court family specialists, who provide counseling and psychological support to parties. And most importantly, we have two more contenders for the Academy Awards that Kevin spoke of earlier. They are the stars of the video clip prepared for you today, and they are eminent family practitioners, both on and off screen. Ms. Poonam Merchandani from Merchandani and Partners, and Ms. Carrie Gill from Harry Laz Partnership. Now we have what is hoped to be an exciting session lined up for you. Dr. Vikki Lenz will start off first by providing us with her opening remarks. We will then break up the discussion into 4 issues. TJ in the pre-courtroom context, TJ in the courtroom itself, placing the children's interests first, and finally maintaining wellness among all TJ practitioners. May I now invite Dr. Vikki Lenz to start us off with her opening remarks. Vikki, please.
Yes, I'm really excited to be here. It's midnight in New York, but this is one of my favorite things to talk about, so I'm wide awake and really looking forward to this. So first, I'd like to say how much I enjoyed the video of Scott and Amanda, which we will be discussing on this panel. It was a great illustration of exactly what we are talking about today, the value of a TJ approach, especially in family court. What struck me is that while law and procedures provided the shell for the case, that is to say the multiple legal applications filed, the form in which they were resolved, the central issue was a social psychological one, how to dissolve a marriage, quiet its angers, and do what's best for the family, and of course Antonia, the 6-year-old girl at the center. I'd like to next say a few words about how I came to think TJ is a perfect fit for family court. I'm a lawyer trained in the adversarial system and also trained as a social worker and social science researcher. I conducted ethnographic studies of family court proceedings involving child abuse and neglect in New York City. As I went from courtroom to courtroom observing different judges, one thing that became clear is that the judges who utilized TJ principles, whether wittingly or unwittingly, had calmer, more respectful courtrooms. Things even got done quicker. The gentler, empathetic, respectful, but firm judges presided over courtrooms where all the various actors, attorneys, parents, worked together towards a common goal. In contrast, the more adversarial judges and attorneys wasted precious time, and time is always at a premium in a courtroom, either sparring with each other or the judge trying to calm down the flare-ups that inevitably occurred because of the emotional minefield of family cases. Breaking up a marriage is hard to do in private, let alone in the forum of a family court, where intimate matters, including the worst moments of marriage, are dissected in public. Imagine the experience of Scott and Amanda, married for several years and with a 6-year-old daughter. The worst moments of their marriage have been exposed. Scott was having an affair, and when Amanda discovered it, she moved out of the marital home with their daughter. There was a fight, and Antonia saw it or got caught in the middle of it. They tried mediation, but the visitation agreement they entered into is falling apart. Scott claims that Amanda is intentionally alienating Antonio from him. Amanda says that Antonio cries and does not want to go with Scott, that she's still experiencing trauma from the fight. Both were unhappy with their first attorneys and hired new ones. At first glance, Scott's attorney seemed to be a zealous advocate for Scott, much like what we expect from attorneys in the adversarial system, who would undo the mistakes of the first attorney. But what he got was an overzealous attorney who did not have the best interest of his child in mind, or even his, and remained argumentative and aggressive throughout, both to the judge and opposing counsel. In contrast, Amanda's attorney exemplified the best practices of TJ. She listened to her client well, engaged her in the decision-making process, and above all, considered what was in the best interest of the child and the family as a whole. The judge, too, expertly employed TJ principles in bringing the parties together and setting a path for them to better co-parent. At this point, I'd like to address the compatibility of TJ with an adversarial legal system by first emphasizing what's the same. First, the players are the same. Lawyers are still lawyers representing the interests of their clients. They do not suddenly become social workers because they are more attuned to the social and psychological. In fact, they are better lawyers because they know how to navigate the turbulent waters of a divorce and its effect on families. The power of judges is the same, with the same authority to direct the court proceedings, including who speaks when, to ask for more information, and to issue court orders. Many of the main components of TJ are, in fact, in sync with the cornerstone of the legal system, due process and the related concept of procedural fairness. Procedural fairness emphasizes how legal systems treat people with a relational aspect of due process. It means an opportunity to be heard a voice and to be treated with respect and to be heard by a neutral judge who does not favor one party over another. These elements parallel TJ's core principles, which similarly emphasize respect, inclusion, and even-handedness. Thus, many of the values of TJ are already embedded in a legal system, if not always emphasized during court proceedings where the hard edges of the legal system may intrude. One ingredient that TJ does add is a different way to promote problem solving. Problem solving is something all attorneys do no matter their approach. It is already part of the family justice system, as evidenced by the rule that the parties engage in mediation and the expectation that throughout legal proceedings, they should make every effort to negotiate their differences. TJ provides a roadmap of how to successfully do this, and it applies to all stages of the litigation, from an attorney's first meeting with a client to discussions between opposing counsel to the courtroom and judge. The problem-solving power of TJ begins at the first meeting between attorney and client. It is essential at this meeting that the lawyers build trust and empathy with clients so they can guide them through the thicket of a divorce. Central to that is giving clients ample space to tell their story at their own pace and in ways that allow the attorneys to more fully understand not only the legal angles of the case, but any emotional and psychological soft spots as well. It means client-centered lawyering, where the client's story has been fully told and their wishes fully understood before any advice is given. This approach also will have added benefits throughout the course of the litigation. When people feel heard, they are also more likely to listen to what may be hard truths. For example, when concessions need to be made in the best interest of the family and children. For opposing counsel, TJ means a healthier and more constructive relationship, disagreeing without being disagreeable, less posturing, more problem solving. In the courtroom, TJ means more of the same. For the judge, it means a judicial demeanor that combines warmth, respect, and even-handedness. It also requires being attuned and responsible to the emotional turmoil underneath and sometimes on the surface. So now let's take a look at the few video clips from Amanda and Scott's story that illustrate the TJ way and its opposite.
Let's play the first video clip for extracts from the continued saga of Amanda and Scott.
Tell me something. You've been the main caregiver. From your point of view, right? It is important that Antonia is in a safe place and access goes well, because you yourself said that you would like to see the relationship restored, so that there can be meaningful relationship, right? From your point of view, how can we achieve that?
I think I want access to still be accompanied, okay? But perhaps instead of he coming over to take the child, perhaps we could bring Antonia over, or we could meet in a neutral location. I think he needs to see that whilst he's very upset that Antonia may not want to see him, he also needs to be more understanding about the situation, that we are trying our best.
Okay, so that's constructive, and perhaps this is something that we can bring up during the hearing.
Hi, Carrie. Not so good. As you know, in that sense, right, following from the last mediation, where I felt that we had to concede on a few points, right? I had to give her interim maintenance, although I feel she actually really doesn't deserve it, right? She has been living a life of luxury in that sense. She's got lots of jewelry. And she basically said that, look, you know what, she offered me some access, which I don't think is reasonable. And
why did you agree to it, Scott? I don't understand.
Well, I felt that my lawyer at mediation in that sense didn't really push hard enough in that sense for me. She said that it's good to take a more progressive approach in terms of step up, right? And actually what I just got was supervised access for the
I
Saturday.
see that the helper is
No, and the worst thing is she's not even, she's still continuing to alienate Antonia, right?
What is
so
she doing?
every time I come for my access in that sense, she'll say that, you know what, she doesn't want to go with me, and then she'll make a big scene of, bringing Antonia to the door, and Antonia will be crying. And I know it can't be true, because, before she took Antonia, right, from the home, my relationship with her was very good.
Yeah,
right?
I saw the affidavits. There are tons of pictures. We put in tons of pictures and all that of you getting along very well with him. to this to begin with. You never should have agreed to the situation. Now she's going to assert that this is the status quo and all that, you know. You've gone for the mediation, the process has been delayed, it's been 5 months. It'll be 5 months since you took out the since you moved out, right? This is going to be a big problem for you. Because the court, they're going to argue that it's the status quo now, and so therefore, you know, this is what she's accustomed to, we shouldn't change that. So that is why, I mean, I don't understand what your lawyer was thinking when they encouraged you to go and settle at this situation. You should have pushed for an urgent hearing as soon as possible. You shouldn't have gone and agreed to all these things.
So I'm really concerned, Carrie, in that sense, right? I don't want this status quo in that sense to continue. Is the court going to approve in that sense of a parental alienation? Is that how they actually reward a parent?
Exactly. This is what I will be arguing. In fact, I believe her lawyer has been calling me. I've gotten several messages already.
Okay.
I think she wants to talk to me about a settlement. But as far as I'm concerned, we are going for full care and control, correct?
Yes.
We're not giving in on just for access or anything like that. We're going full on. Yeah. I mean, I agree with you. Alienation is a huge issue. There are many cases in Singapore where, you know, when there's alienation, the court has reversed care and control. So that's what we'll be fighting for.
That's good.
Yeah, that's what we'll be arguing for.
Hello.
Hey, hi, Carrie. This is Poonam. How are you?
Who is this?
Poonam Rajandani.
Hi, Poonam. Let me put you on speaker, yeah? Yeah, what's up?
Yeah. Carrie, can I just check with you if there's anyone else in your room? Because I'd like to discuss the case of Amanda Arden and Scott Morrison.
You asked me whether there's anybody else in my room in my law firm? No.
Okay, that's good. Carrie, just wanted to discuss this matter. As you know, it's coming up for hearing, and this really is an exploratory call on a WP basis. You know, Carrie, I was just wondering whether you and I as counsels can address some of the concerns that are happening, you know, with respect to Amanda during access. I understand it's not going as smoothly as it should.
Poonam, I'm not sure what's the point of this because my client wants care and control. We're not interested in access. Your client, stole the child away, has been alienating the child. My client has no interest in access. He wants full care and control.
Yeah. Carrie, I hear you. I know there is a cross application filed by your client, my client. That matter's coming up for hearing. As you know, there is a CER report. Perhaps it will be helpful if we all just wait and see what the CER report reveals. But in the meanwhile, right, there is 1 week more. There are 2 further accesses, and I'm sure DJ Chin will want us to address on the issue of access. So wondering whether we can have a conversation. I understand that it's been accompanied access, and despite that, it is not going as smoothly as it should. And I'm sure your client would be interested also in having meaningful contact with the child.
No, Poonam, let's not waste time, okay? The hearing is next week. I'm going for full care and control next week. I'm not interested in waiting for the CER. I'll be asking the court to make decisions immediately. This has been going on for too long. It's been 5 months. Your client has been delaying, has been avoiding access, has been doing everything she can to destroy the relationship between the father and the child, and enough is enough. So we're just proceeding on next week. There's nothing to talk about, honestly, Poonam.
All right, Carrie. Again, I'm sure you've read the affidavits. You know what Antonia is facing. She's undergoing play therapy, right? She reacts.
Yeah, Poonam, that's all because of your client. It is your client's fault that she's going through all of this because she was wrenched away from her home. What do you expect the poor child to be going through?
Carrie, would you just please let me finish? If you go through the report, right, which has been filed with my client's affidavit, the child is facing real issues, you know. So I think it really will be helpful. These are child-related matters.
No, I've made myself very clear. I can make it to you. We are going on for a hearing. We're fighting for full care and control and access to your client. There's nothing further to discuss. There's nothing else, no middle ground here for us. Okay, I'll just see you next week at the hearing.
All right, Carrie.
Bye.
Hello?
Yes, I think the clips you've seen so far have showcased 2 very opposite approaches by the counsel in the pre-courtroom context. So now I'd like to invite the panelists to discuss what it means to adopt TJ in the course of client discussions as well as in written communications, and negotiations with opposing counsel, perhaps two questions come to mind. Can the playing field be leveled so that a TJ-minded party is not taken advantage of when trying to be more conciliatory in the process? And perhaps the second question that comes to mind is, between counsel and client, is there a conflict between business sustainability and maintaining a TJ approach? Can clients be educated to appreciate the true value of a TJ-minded lawyer? Maybe I'll turn first to Vikki for comments, and then I'll open it up to the rest of the panel.
Yeah, so I'd like to start out by commenting a bit about what went wrong. And I think through the comments, the answer to your question about whether it's business stability, if it's okay, it will alienate clients, will come through in describing the different ways that the attorneys handled it. So both Amanda and Scott came to their meetings with their new attorneys, regretting entering into the interim orders, and they were both dissatisfied as to how Scott's visits with Antonio were going. Scott's attorney's approach was to take aim at both her own client's judgment and the legal system itself. So when she said things like, "Why did you agree to it? I don't understand. The problem here is you agreed to it. You never should have agreed to it." This is not a way to establish trust with clients, because she's chastising him and telling him it's going to be a big problem for him. She's also casting doubt on the usefulness of counseling interviews, the usefulness of talking to opposing counsel. And one of the things that she does in terms of the attorney-client relationship is she actually decided for Scott whether or not negotiations should happen. She was so assertive in her approach, she gave no space for him to say what he wanted or for him to process what was going on and think about what was the best thing. And she essentially decided that she has no interest in speaking to counsel, and at that point, Scott just went along with it. So I think that she failed the most basic principle of client-centered lawyering within an adversarial system, and that she had no interest in speaking with opposing counsel even before she asked what he wanted. So if you contrast that with Amanda, she wanted her attorney to make clear to the court initially, and this is from the original video, that she can't be bullied into accepting an arrangement that doesn't work. So she came in angry also. But the course and the outcome of this meeting was very different and exemplified the best practices of TJ. So the attorney took her time to gather information without overlaying her own interpretation of it first. Rather than egging her on, as Scott's attorney did, she asked about the history of the relationship between the father and daughter, established that it was a good one, but then also validated her concerns about safety when Amanda described how Antonio was caught up in the couple's violent argument. And one of the best things she did was when she asked this question, from the client's point of view, how can the relationship be restored? At which point Amanda made suggestions that the attorney described as constructive. So she was setting it up from the initial interview as to how to help this family and to elicit from them, her client, what was the best way to do that, to try and to get Amanda to shift to a more conciliatory mode, which would be better for the child and the family as a whole. So I think that these different approaches, one is more sustainable than the other, just in terms of even the adversarial system and doing what your client wants. You first have to find out what they want and talk to them about it. I think actually Amanda's attorney, who used a TJ approach, will have better relationships and better success as an attorney. I would prefer to go to her if it was me. So that's my take on that discussion. The phone call was more of the same. The disrespect shown to the other attorney, throwing her phone down and putting her on speaker, seemingly just the confidentiality. And then listening to the language, she spent the rest of the time denigrating the mother, a tactic which she continued later on, she'll talk about later. And as she said, there's no middle ground. And there's always a middle ground, or an attempt at least to find one in good lawyering.
I see Poonam raring to go. Poonam?
First of all, can I say, if I was deciding and if I was on the board, Carrie would get the Academy Prize for this one, for being really the best actress, right? And really, we were acting. These were roles we were playing, right? Some portions of it were difficult. I did have to bite my tongue sometimes when Carrie was having a go at me. But I think Vikki has covered it wonderfully, and I'm going to move away from the clip, right? Really, to my mind, what really is this big question? Those of us who have practiced in the space for 30 years now in an adversarial system, how do we communicate not just to clients but to the bar at large, right? All the players in the family justice system, that advocacy in the family law, right, is not being combative. It doesn't necessarily mean being combative or adversarial. That, to my mind, is a big challenge. And that is something we need to convince family practitioners out there that the tone is set, quite honestly, from the very beginning, from the get-go, when you see your client, of course, when you have a client who comes in, you allow it's important that clients feel that they are heard, and giving them the first 15, 20 minutes, whatever the situation is, for them to vent how they feel, their frustration, their anger, their guilt, whatever it is, and then getting them to focus back to really what the common interests are. And the common interests, especially when there are children, has to be the kids, the best interests of the kids and the family at large. And I found myself when I was with Amanda, right, because she had switched lawyers, I tried bringing her back, and we succeeded in bringing her back to focus on Amanda's interest, Antonio's interest, And that way, it was very easy if the situation ever detracted or derailed, I could then bring my client back and said, hey, do you remember that this is exactly what you said your interest is at the first meeting? So for me, how does one deal with a client? It's to get the client to move away from positions and explore solutions. And that's what that clip demonstrates. Now, for me, as a practitioner of over 30 years, I think having a camaraderie and some sort of a relationship with the opposing counsel is very, very important. TJ doesn't mean you are weak, right? TJ just means that you are exploring the different options available, with the opposing counsel, while moving the processes of court ahead, not compromising your client's interest, be it in correspondence, in communication, in what have you, but communicating to the other party that you are open to exploring, including the ADR route. I mean, TJ has been around. The seeds of TJ was sown many, many years ago when mediation was introduced, counseling was introduced. One of the big challenges for me in practice is not my client really, it's dealing with the opposing counsels, which I suppose we can deal with a little later. Over to you.
Sophia?
Yes, so I do concur with what's been said so far. I think one of the thoughts I have is this, that I think it's quite possible to have deep differences and substantive issues that we are not agreeing on without it being high conflict. And it is possible to have a very simple conflict in terms of the nature of the issues. There could be a very simple problem regarding access, but it could be a high conflict situation. This is what I mean. I think when we think about high conflict, we think about polarized position with highly charged emotions and reactions because of perceived unreasonableness or aggressiveness of the other party, isn't it? And I think we all know from also communication theory that how we say often communicates more than what we say. And I think from the video clips exchanges between the lawyers and we see a huge contrast in terms of the demeanor, the language use, the non-verbals, and I think a lot of which Vikki has already pointed out. But I just want to add that I think one of the ways that sometimes we recognize that we are in a high conflict situation, that we have a high conflict opponent, I think maybe a couple of things come to my mind. One is where the discussion is very much solution focused, even though people's demeanor and you might be a bit upset about things. Generally, I would say that is a good problem solving, I think, as Vikki framed it. Vis-a-vis another context where you could actually have a very calm conversation, but the entire discussion is surrounding blame, other features that come in, a very patronizing way of speaking. I mean, sometimes I have noticed that we can say things very sarcastically, but in a very polite manner, a very calm tone. And it's still a high conflict situation. So I just want to bring to our attention that high conflict sometimes doesn't mean just simply high emotive, aggressive, but really what we are looking at is whether, in terms of the themes in the conversation, a lot has to do with blaming the other person, positioning, using misconstrued words, using over-the-top language, sometimes a lot of ambushing type of listening and conversation. I think those are your cues that your opponent may not be so TJ-minded, but they are really there to ambush you and just digging their heels. And so I think, being human, I think we are naturally triggered by such unfriendly and still a hostile postures or tone. The challenges, sometimes even you want to be very TJ-minded, we can get very triggered. And sometimes we get entrapped. I call it an entrapment for us to start reacting, and you find ourselves getting anxious, getting angry within us. And very soon, we get led into a conversation, a fight with the opponent. But I think in the video that we show, I mean, it showed Poonam, absolutely a class act in not allowing yourself to be pulled into the conversation by Carrie. And I thought those are, I think, tips. You stay calm, you don't make it worse, and you keep focusing on the issue, big picture, and you, your words, your phrasing was about how do we solve the problem, and you try to put in the positive. And I think you try to highlight some common grounds, in terms of access, we can go slow, and this is what the judge would like us to do to solve. So those are very good, I think, very good things that you say. The other thing I want to say in dealing with high conflict component is that sometimes limit your electronic exchanges. What do I mean by that? I think emails are sometimes a blessing and also a bane when we are dealing with people who are very positional. And emails, as you know, you can't hear the tone, you're not sure where it is. So sometimes for difficult issues, it might be easier to pick up the phone and talk. So I thought that was a good illustration of the modes that you might want to use. And I think the other point I want to say is that being a TJ-minded means that when we are encountering a high component, it's not there to identify, to say, aha, you're a bad hat, you're not TJ-minded, but really it's about managing our own emotions, and I think suspending our own judgment on the motivation of the other party, and just keep focused on what is the issue, what are the common interests, and how do we want to resolve a problem. Yeah,
I think it's a good point to see how the conflict actually dials up as we go into the courtroom process.
Yeah.
So let's play the second clip extract.
What about your client's position?
Yes, Your Honor, as I was saying, since she stole Antonia from the matrimonial home, she has pretty much refused to let him see Antonia. Her anger at my client for having fallen in love with someone else was so great that she would deny him any contact with the child. She even went so far as to take out PPO applications against my client on behalf of the child and herself, when there has never been any family violence committed by my client against the child. Clearly, she has been advised to make spurious allegations to deny him his rights to the child. It is malicious and deplorable behavior, Your Honor.
Okay, Ms. Gill, let's just focus on the issues today. I'm going to be hearing only on the issue of custody, care, and control. So let's try and sort that issue out before we before we move on to the other issues.
Just one thing before we progress any further. As your Honour knows, the councils had filed written submissions. I just want to say, as directed, my client filed 2 affidavits. The father has filed a total of 5 affidavits, right? Insofar as the written submissions are concerned, Your Honour, because the mother did not have an opportunity to respond to the 3 affidavits which were filed without leave, I wish for it to be recorded, if I may ask humbly, that the written submissions on our part, Your Honour, is confined only to the 2 affidavits as directed by court. I would just like some clarity, if I may.
Okay.
I object, Your Honour. These are important affidavits. They're relevant to the issues at hand, and they should be admitted.
Okay, Ms. Gill, please don't interrupt me. All right, now, I've heard what both parties have had to say. I'll proceed with the hearing right now, and along the way, where necessary, I'll determine whether or not further affidavits or evidence is required. So you can take all affidavits and submissions as read, and we will start with the hearing. Okay, Ms. Gill, please do not interrupt me again, okay? Now, we will just proceed with the hearing of the cross applications. I'd like to do this methodically, all right? So let's start off with the issue of care and control. And Council, please proceed to highlight your points.
Yeah, Yuna, if I may, thank you very much. I propose to deal with both the...
With all due respect to Ms. Chandani, my client filed his application first, and accordingly, I shall start with my client's case first. If I can refer Your Honour to my submissions filed yesterday at paragraph 6.
Okay, Ms. Gill, hold on, all right? Now, I'll make it clear, and we will proceed as follows. Counsel for the father will start, followed by Ms. Merchandani, Mother's Counsel. Thereafter...
Your Honour, if I can refer you to paragraph 6 of my submissions, Your Honour will see that where we have stated that the father's relationship with the daughter prior to her being kidnapped from the house, she was getting along great with the dad, she would have weekends with the dad. There are a lot of pictures we have accepted. If I can refer Your Honour to tabs 6 and 7 of my affidavit filed on the second affidavit, Your Honour.
Yes.
If I can continue that.
Could I just ask you to highlight the key points of your written submissions, because I've already stated that I've read your written submissions.
Issues concerning what Antonia is going through needs to be addressed by counsel, Your Honour, with openness, with candor, and with inclusiveness. It cannot just be a situation, Your Honour, where we are looking from the father's perspective. I want to explore, Your Honour, together with, of course, Ms. Gill, what the shared interest of the parties is, and it has to be Antonia. There's one more thing I want to...
I'm sorry, but it does not lie in Ms. Merchandani's mouth to deny when the facts speak for themselves. The child was fine with him before. Mother clearly has been advised to create this false status quo to deny him his child. It's repulsive behavior.
Ms. Gill, I've reminded you before, please do not interrupt the court nor counsel, all right? So Ms. Merchandani was speaking when you interrupted her. You will be given the opportunity to respond later on. So please allow Ms. Merchandani to finish. Ms. Merchandani considered all of the evidence before me and taking into consideration what is in the best interest of Antonia. I am granting care and control of Antonia to the wife with very liberal access to the husband.
You are giving her care and control? She stole Antonia and kept her away from me, you know, and you're rewarding her?
Don't worry, we will agree on this decision. Your Honour, I urge you to reconsider your decision. Creating authority that encourages litigants and their lawyers to steal children from the other parent and keep them away, and then to use and argue that as a status quo and succeed, Your Honour?
So it is really important that we focus on trying to help Antonio get past these issues and establish a new normal.
Well, I didn't know that Antonia saw or heard about that incident. I mean, I thought that she was sleeping at a particular point of time. Is she all right?
Well, she's been attending some counseling, and it appears that she's doing reasonably well with the current arrangements. This is why I hesitate to introduce too many changes at this point in time. Now, the access arrangements are very, very liberal, and it will provide you with overnight access on weekends, when you will be able to spend quality and uninterrupted time with Antonia. With this arrangement, I believe that Antonia would have the best of both worlds. Time with you, and also time with you, Ms. Arden. As you may be aware, social science studies do indicate that children who emerge from divorced families do better in the long run when they have a relationship with both mother and father, and the parents are both involved in their lives.
So we've seen in these series of clips the different approaches to advocacy in the courtroom, and also how a judge could handle communicating a decision to parties. So there are actually quite a few questions that are raised for discussion here. The most primary one probably being what are the do's and don'ts in the courtroom. And perhaps if I can add to that, I see one question that's come up from the audience, which is that if we all focus on TJ essentially, is there a risk of alienating the litigant who wants to have a satisfactory judicial process? More specifically, if a client has been instructed, how does the client balance between trying to be TJ and trying to adhere to the instructions and the intent of the client? Maybe I'll just open to Vikki for some quick comments and then views from the rest of the panelists.
Yeah, so I think what you saw in the courtroom was replicating what was happening outside of the courtroom. But the thing I'd like to focus on very briefly is just the narratives, that what you do in a courtroom is present narratives, and you can see just in the language that was used, when you consider the language used by Scott's attorney, she stole the child away, wrenched her away, kidnapped from the house. She's a terrible mother. There was throughout the full clip and parts of that clip, it was very negative language in contrast to Amanda's. So I think Amanda's attorney really spoke about what was at the heart of the case and about what she needs. And when you see them side by side like that, I don't think it's just like TJ or non-TJ to address that question. It's which is more effective and which is the better way to present in court. And you could see the judge getting annoyed with Scott's attorney. So even in that approach, I think to understand that doesn't represent your client well. And it doesn't help the matter. So you're not going to win your case, most likely, if you persist on acting like that. So if when you talk about a TJ lawyer and a non-TJ lawyer, and whether there's a conflict when somebody doesn't want to be a TJ lawyer, I think that happens ordinarily in the adversarial system when different people's personalities and behaviors and emotions play a role in how they present. And that I think there's a lot to be said, and Sophie touched on this, that you can help influence that environment by being the calm, more deliberate one. I mean, Carrie did this amazing job. I was afraid of her after watching the clips, but I think that in the end, Poonan's way of approaching it and the judge's way of approaching it will influence the atmosphere and the environment in the courtroom. And I just want to really quickly talk about the judge's order, because I think you could not find a better script for the TJ approach. There was a piece of it that wasn't included here where the judge actually talks about how both parents tried their best to co-parent, and Antonia was growing up nicely and is a credit to both of you. Both parents love her and have contributed to her growth. And then she says, but she spends most of the time with her mother and it's in her best interest to be with the wife. And just the fact that she brought the father into the conversation, didn't chastise him, complimented him, was, I think, the start of repairing the relationship. And you saw at the end of it that Scott actually accepts what's happening. And I think a large part of that was because of the judge and in spite of his attorney.
Maybe Suzanne, would you like to comment a little bit? You're muted, Suzanne.
Okay, thank you, Registrar. Okay, so you, during the clip, right, one of the things that emerged was the affidavits, the number of affidavits. And I think really what happens
before the court hearing, before we come to the court, from the very first meeting, the earlier clips, that actually, as I think has said before, sets the tone, and on the negative side, entrenches the parties in their position. So throughout, you can see that, Poonam adopted a very collaborative approach and tried to be conciliatory, tried to provide suggestions, and her focus was always on trying to come up with a solution that would be in the best interest of the clients and the child involved. Carrie, on the other hand, perfect acting, but, she was hell-bent on just making sure that she won the case. And to her, winning the case was all about making sure her client got exactly what he wanted. And I think TJ demands something a bit more thoughtful and focused, in the sense that you need to listen to your clients and understand what the underlying issues are, what the fears are, and then come up with ideas or solutions that can address those issues. And I think Poonam was throughout, and representing her client as well, she represented the client in a manner that was very clear. She was listening to what the client wanted. Carrie had her own idea. So this showed through in the court proceedings as well. And you will also see that there were multiple applications, and all that was caused by the original entrenched positions that were taken. Now, in the courtroom, obviously there are do's and don'ts, and these were quite apparent. I think one of the things that I touched on earlier was, coming with a conciliatory and cooperative approach. And this was very clearly depicted by both Ms. Gill and Ms. Merchandani. Parties themselves are already acrimonious, so we don't need the lawyers to come to court with that kind of attitude as well. The lawyers should be there to play a role as part of the team. We talk about the multidisciplinary team, and the lawyers are very much part of that multidisciplinary team to try and come up with some solution that is sustainable for the family going forward. I think one of the questions also raised earlier was this issue of how we represent the client, how the lawyers are expected to represent their client, and what if the clients do not buy into the TJ approach. I think the point here is that lawyers are there, you're retained to represent your client's best interest. The question really is, what is your client's best interest? Is it to win at all costs? Then what happens? You have a situation where he may have care and control, but the reality was in the video, you'll see that Scott really had to work most of the time. He had a very onerous job. He had a job which took much of his time. So the reality was he didn't have time for the child anyway. And if Ms. Gill's position had prevailed, so he would have that the child would just have been left with a domestic helper, and that's not necessarily the best interest. I think the focus should be on what is the best interest of the family, and how we as part of a team can work towards coming up with a solution that is sustainable for the family, and it does not mean they will keep coming back to court all the time.
Carrie, do you have any thoughts about your alter ego performance in the video?
Sorry, I couldn't figure out the mute button. Yes, I completely agree with what DJ Chin had to say, and what are the do's and don'ts of litigation or TJ litigation. But what stands out to me essentially is, I think one of the, if you look from the video, I never took any of the judge's cues throughout the proceedings. I was just going on my own tangent. I didn't care what she had to say. And I think that's something that we all need to be more aware of, is the fact that we need to take the judge's lead in the conduct of our arguments. When we first come into the hearing, the judge would have given you a game plan as to how she wants to take it forward, whether she's read everything already, whether she just wants a summary of the case, or just focus on specific issues. We need to, take the judge's lead when we're dealing with that in the conduct of our arguments, focusing on issues and suggesting solutions rather than going on and on about what the other side has done wrong, what the mother or the father has done wrong. And that was what I was essentially doing during the hearing, was to just keep going on and on about the fact that the mother was a terrible mother, that she kidnapped the child, in my bid to try and influence the judge against the mother and therefore in favor of the father. That unfortunately does not go very far, and that's the reality of the situation. The judges are focused on the issues on what is best for the children and achieving the best solution for the children. And if we can aid in that process, I think that's what our role has to be as well. Courtesy, basic courtesy, it really, really goes a long way. I mean, you treat everybody in a hearing, the same way that you would want to be treated, essentially. If the other party is rude or belligerent, you should trust the judge, take control of the proceedings. Don't feel the necessity to jump in and say, stop interrupting me, I object to this, I object to that because you're being rude. Don't say any of that. Let the judge handle it and you just wait your turn. That was what Poonam was doing, which was very, very difficult for her. I think we can all agree. But she was able to control herself and let DJ Chin take conduct and control of those proceedings. Finally, the last thing that I wanted to say was, I think that what was very useful here was that the parties were brought into the process at the end in the decision, for the decision, and it was explained to them why a decision was made, what was the purpose of it, and what the judge hoped to see moving forward. And I think that was really important for the parties to then, one, accept the decision and move on as well, move forward together as a family. That to me was very, very useful. If that is not possible, obviously we can't do it for every single case that happens. I think the other thing that is very useful is to always have your basic grounds of decision by any of the judges when it comes to child-related applications, so that it makes it easier for us to then explain your rationale to our clients. If there is a basis, a rationale that can be explained, it would be easier for the parties to swallow and move forward with that decision instead of just reacting and filing an appeal straight away. So that's for me. I hand it back to you, Registrar.
Okay, I think this is a good point to move on to the next issue, which is about putting the child's interest first. Let's see a short clip.
My question to you is, okay, there is the CER that's ongoing, right?
Yeah.
How has that been happening? Have you done the interviews?
Yeah, we've gone for a few interviews in that sense. I think that's something which was ordered by
Did
the
you?
court.
Oh, you didn't agree to this, right?
No, I didn't agree to that.
Did your lawyer object? Because I know it's really a bad idea to do these things. Because once you do it, she's already alienated the child, she's already manipulated the child. They go to the CR and she's going to say whatever the mother has parented.
Yeah, so actually I don't see the utility of the whole process, and that's why, Carrie, I've come to actually see you, right? Because I'm not happy, and I think we really need to push. At the mediation stage, I felt that, I more or less had to kind of give in with regards to care and control. But
Did you feel pressured? By the judge?
The decision was mine, I think, to be fair. That decision was mine. But at the end of the day, I felt that, it could have been a case whereby we push harder to say, look,
the children are young and malleable. They can adjust. Ms. Merchandani wants the child to attend counseling and for supervised access to take place. All this is completely unnecessary and it's a waste of time.
So we've seen from the clips before how we try and get all parties to focus beyond the dispute and to put priority in the welfare of the child. So really the questions that arise are, how do we ascertain the best interest of the child? Should we do it via custody evaluation reports, judicial interviews, or to hear parties out directly? And are there attendant concerns about triangulation of the child and gatekeeping and so on? And a further question that has been raised from the audience is, how about other interests? How about the interests of family members staying with family, say grandparents and so on? Would their interests in relation to the children also be taken into consideration? Maybe, Sophia, let's start off with some observations.
Yeah, I think hearing the voice, the child's voice has been, quite a big thing especially over the last couple of years, where I think the sensitivity to the child's rights and the awareness that, the child is not a passive player in the entire divorce process, I think has been a kind of a good move. The big issue is always how and what do we do, as you said. I think I have a little idealistic thinking about this. In my mind, I think if there is a family law system where it is really a non-adversarial system, where everyone is in a problem-solving mode, from the judges to the lawyers, and where the affidavits that are written are presented in a way that is not to find fault, but presenting a true picture of concerns minus the sarcasm, intentional half-truth, where there is a peacemaking stance, even in the way that you write those affidavits. And everyone is well trained to put in the right elements. My sense is that parties probably can seek a collaborative solution without actually needing to involve the kids, where everyone is in the right place. But of course, like I said, this is probably an ideal world somewhere else. So my point is that so for the courts, I think we use many means, right? We first try to help the parents themselves because I think at the end of the day, we recognize that whatever it is, parents do know their children, or at least a lot of them do. But sometimes in the midst of their fights, in the midst of their own wounds, they lose sight of what's happening. And I think it is our job, and the job of the professionals and the job of the lawyers to help them refocus where they're thinking about the child's rights. So in the court, we use mediation, and I think you've heard of child-focused mediation, where we try to steer the conversation and move the parents to think about their children as parents. Because when we are in a fight, we always think that we are right, and many of the parties who are caught in the divorce sometimes cannot differentiate between their spousal role from their parenting role. I mean, of course, we are one person, but I think the whole purpose of a more child-focused mediation is really trying to help parties to shift from a spousal context to thinking as parents. Just like you're lawyers, you're also a mother, you're also a child, and in different contexts, we somehow behave differently and think differently. So I think the whole idea of collaborative discussion is to help people deal with that. So that's one means that we do. Occasionally, we will facilitate with Child Inclusive, where we help them hear the child's voice by having a specialist talk to the kid, and then presenting it therapeutically back to the parents as a feedback to say, hey, this is what your kids are experiencing. And that's another way, I think, to ascertain sometimes the best interest through the eyes and very collaborative means. Of course, then there are other different ways. Then we want to talk about CER, which is custody evaluation. I want to say first and foremost that speaking as having done this field for a long time, I really feel that the custody evaluation report, while it is an investigative report that can help you ascertain a holistic picture of parenting capacity, children's needs, and maybe also address the interest that raised in the question, that there are also grandparents' interests, there are the other significant people in the family that we have to take cognizance of in terms of building a future plan. And the CER does that for the courts, because we explore, we check in all the significant parties, and it's not. And the other thing I want to raise is that it is not just an interview, it is about observation. It is about gathering corroborative evidence from counselors, from school teachers, from any mental health professionals, and using psychological theories and to evaluate the congruence between what is presented and what research data tells us. So I think it's quite I would say a psychological structured process. In that, I think, while it gives us a lot of views, but I think it is very invasive and very detrimental actually to family relationship. Because I think Carrie in the portrayal as the lawyer who says that, oh, this is terrible. I mean, in some ways, there is some truth to that. Because when you have to subject an entire family under the microscope to see what is wrong with you. It's like sending a family to an oncologist and to do a biopsy on the on the family to tell them where is your malignant growth and what you need to do about it. So I think it's a double-edged sword that we have to use it very carefully. I'm sorry, I'm taking a little longer. I just want to raise another point too about the danger of also overhearing the voice of children. I think in our efforts the consequence to that is sometimes the children gets interviewed over and over again. They go through mediation, they talk to the lawyers, and sometimes the parents get a bit freaky. They send them to a psychologist, and then if they fight some more, they get sent to a supervised visitation services where the social workers are there to help them, and the story is repeated. Sometimes the lawyers, the judge want to talk to them, and the children have to speak again, and then it goes through a CER. So you think about the process. I mean, the kids actually get pretty exposed, and we have to think about how we can better help them and protect them, even if it is in the spirit of we want to try to see what is best for them. So
it's good to hear from the lawyers at this point about your experience when children are subject to these various tools that judges use to find out more about the family.
Yeah. I couldn't agree with Sophia more in your analysis, Sophia. In my practice of family law, and indeed anyone who has practiced family law, any other form of law, how often is it that our views are jaundiced through what the client says or feels, and then you advocate that, your client's position? How often is it that you believe what the client says about the other spouse vis-a-vis the child or children is correct, i.e. the gatekeeping, the alienation, and what have you? We had a recent case where the CER actually opened our eyes, not just the eyes of the client, but the eyes of the lawyers as well, because I think it's really important to tell your client, have faith in the process, the family justice system, the various things that are in place, the multidisciplinary team that is in place, they know what they are doing. And to impress upon them that the findings of the CER doesn't necessarily mean that that's going to be the outcome of the case. In my mind, to practice family law successfully, it is so important to redefine victory, to redefine success, because really, this is the one court where there are no winners as such. It is important really to impress upon the client that the voice of the child must be heard, and it is not the victory is not defined by the orders that you have prayed for, but rather what really is in the best interest of the children. In the clip that we saw, and Carrie demonstrated this beautifully, she did not once ask Scott, what is in the best interest of Amanda? She never did the reality check, pushing for care and control when he is so busy. Is this really what the child wants? And sometimes you don't even need the CER report. By the lawyers asking the right questions and speaking of hard truth. And this is what I call empathy with fairness. When it comes to listening, you listen, but you've got to also be ready as a family practitioner to say, I don't think this is it. To call out gatekeeping, to call out alienation, to call out parentification by a parent. That is just so important. Redefining success, getting the client to change his or her mindset that success really means the best outcome for the family. Therein lies the challenge, to move a client from victory in wanting to annihilate the spouse and saying, look, let's focus on the child. That is a big challenge, and I think often we can succeed, and lawyers can mitigate the whole processes and the dispute and the damage.
Right, maybe in the interest of time, I quickly jump to the last issue, which is about wellness and mindfulness. So having a TJ mindset really requires all parties, judges, lawyers, and clients to be in the right mind space, to be emotionally resilient, to be balanced. And how do we ensure that we achieve this positive state of mind? The process is one which involves winning and losing. How do we depersonalize this? How do we avoid burnout and avoid transference of emotions perhaps to our personal lives?
Yes, if I could jump in here. I know we're very short on time, so I'm going to try and keep it as brief as possible. I know lunchtime is very important to everyone. But this issue of mental health, I think, is one of the most important aspects in family lawyers' lives, which is very rarely discussed. You know, how to maintain our own mental health when we're dealing with a multitude of clients who are going through what is possibly the worst period of their life and who are constantly unloading, offloading their emotions on us. How do we stay focused? How do we stay balanced and hopefully unaffected by the same? Like I said, this is an issue that affects family lawyers more so than any other field of law, in my opinion. Now, the reality is that it comes with practice. It is very usual for junior practitioners to become emotionally involved in their clients' cases simply because the situations are probably new to them and they simply do not have the emotional maturity to divorce themselves from their clients' cases. I personally was exactly the same in my youth. I like to think I've mellowed with age, but I have myself put myself in some very dangerous situations because I felt so strongly for my clients, especially those that were victims of abuse. The trick is to empathize and not sympathize. Don't bring your own emotions into the picture. At the end of the day, this is just a job. Yes, we feel for our clients and want to achieve the best outcomes for them, but you should not place your own value based on whether you succeed or not for your clients. You do the best you can, and then you move on regardless of the outcome. As a more senior member of the bar once told me, all we can do is do the best job for our client, and the rest is their karma. It is not on you, and that has stuck with me as well. I do believe in karma. The other things that I feel you must do is you must have an activity outside of work, be it spending time with your family, a hobby, a sport, drinking copious amounts of alcohol with your friends, whatever it is, choose something. You must set aside time for yourself to enjoy the things that you enjoy and shut out work completely. I know this is easier said than done. I myself have never taken even one day off from work or clients since I started practicing family law full time. But what I do is I ensure that I have a few hours each day where I do not look at any emails, I don't do any drafting, and instead I spend time with my family or friends.
And so, this is getting harder in the pandemic. All of us only having a relationship with the computer and the emails.
Correct, that's true. So, but the point is, you need to be fully present in whatever you're engaging in those activities you're engaging in, and that, I believe, helps you maintain a healthy work-life balance. Okay, that's all from me.
Any other views?
I'd like to add something to that using a TJ approach is actually a way to make the workday more pleasant and to feel less of that pressure because you're not getting into high stakes conflict and you're likely to have better outcomes and feel better about what you're doing. So TJ is actually very helpful for attorneys.
Yeah. May I just add, as a fellow practitioner, now, I think it's important to be kind to your opponent, to the opposing counsel. Absolutely important because the transference of emotion, as Judge Yap, you were speaking about, happens just not from clients but from lawyers as well. Developing a camaraderie at the bar is just so important. It does so much for the wellness of your own mental well-being to start with, you know. So for me, that's been really important. The ability to be friendly, but to progress the client's case, i.e. by picking up that phone call and having a chat with the opposing lawyer and not to get into combative. Carrie and I have often picked up the phone after hours while she's having a glass of wine and me my beer, whatever, and we're chatting.
I will interrupt. It's always whiskey, never wine with me.
Actually, it's wine for me. And it feels wonderful to be able to do that, you know. And you know that even if the judge has held against you, right, it is because
because of merits of the case. By merits, I say the judge taking into account all the interest. That for me has just been brilliant. It is in a case where you are constantly combative that you bring your vows at home, and that's not very healthy for family life for lawyers.
I think I won't share what judges drink, but we share our vows with each other. So maybe as a parting shot, can I invite all of you to maybe just choose one aspect of change that you think would be most effective to actualize TJ? What is that one thing on your wish list?
From my perspective, really to effect it, there needs to be a mindset change. And how do you achieve that mindset change? It has to come with training. It has to come with education. Because I think a lot of us are still focused, and I think what we didn't cover is the issue of how we balance our business life and the TJ approach. And that's something I think was missing in our conversation. Is we have clients who are difficult, especially the more sometimes the high net worth individuals, and they are the ones who are looking for lawyers who want to fight. They're not interested in TJ lawyers. So, and those are also the ones with the deeper pockets. How do we as lawyers balance that essentially? So I think that's where the training will come in, the education will come in, how to manage those aspects and ensure you still have an effective business, a good business, and whilst maintaining this TJ approach. That's me.
I'd like to add on to that. My one wish list is really to see the court and the judges frown upon non-TJ lawyers, to call it out, and to basically, the message must be non-TJ conduct, whether it's by correspondence, affidavits, courtroom, advocacy, it will not be tolerated. So not just to call it out to the lawyer, but be prepared to commend lawyers who do practice TJ. How often is it that someone says, I embrace TJ, but that lawyer is anything but TJ? So I think it is time for the courts to speak louder in praise of TJ rather than non-TJ practices.
Just to jump on that point, I actually think that's a very, very valid point, because there are some occasions when we feel that the judges may not be as strong enough when they could be in ensuring that this kind of behavior stops. So I do agree with Pudam on that one. Be more stronger in that respect when you're dealing with a non-TJ lawyer. Stop them quite quickly in their tracks.
That's something that we definitely take on board. Suzanne, any thoughts on that?
I think the role of the judge. I'm sorry, you go.
It's okay, Vikki, you go ahead first.
Just going to say that.
Oops. Vikki, you're muted.
You're on mute, Vikki.
Sorry. I think the role of the judge is key, because when I did my observations, that made all the difference in the world, how the judge set the tone in the courtroom. So I totally agree with that, about judges setting the stage, modeling it.
Suzanne?
Yeah. Okay, just to follow up on what Carrie and Poonam have said, that I think the lawyers play a role, but just a reminder that we all work together as a team. Everyone has a part to play, a different aspect, but we work and we journey with these parties, and hopefully if they're ready to settle at mediation, then we work towards having them reach a solution at mediation. If at a later stage they can't reach any consensus at mediation, then we go through the adjudication process with them. But even through that adjudication process, we work as a team in a collaborative and cooperative atmosphere. And I think eventually, if that's the case, that TJ will become part of a new normal in the FJC.
And Sophia, your last word is the wish list.
So speaking as a social science specialist in that field, I think it has been a wonderful shift in embracing my colleagues and this field in thinking about helping the families. What I hope and my wish list would be that there will be more conversation and more collaboration and partnering between the social science practitioners and the mental health, together with the lawyers to help the families. And I think by ourselves, I think we can't do very much, even as a mental health professional. Sometimes we can only deal partially. But I think together with a legal professional, I think it becomes a real holistic, we provide a real holistic solution for for the family. So, and I that would be my wish.
Well, thank you everyone for all your comments. I think it's clear that there are many, many moving parts to the TJ puzzle, and I hope that today's conversation has shed some light on it. I think if anything, it's opened up more questions than it's given answers. Each one of the topics that we raised today is really capable of an entire session unto itself. Today has been a very good session, and I thank all the panelists for their participation. And over to you, Darren.
Once again, thank you very much to all the panelists and to the moderator for that very, very engaging session. Well, ladies and gentlemen, how did any of you know Darth Vader was a woman? There you are. And one thing, as the closing line from Sophia Ang says, it's working together. So continuing the Star Wars theme, the alliance must hold or else the Empire will strike back. Ladies and gentlemen, the morning session has come to an end. We now take a break for 1 hour. The afternoon session will start punctually at 2 p.m. A gentle reminder to everyone to ensure your MicePad webinar window remains open on your device for the entire duration of today's conference, as this allows for attendance and attentiveness taking for public CPD points. Take a break, forget whatever, as Carrie says, do whatever you need to refresh yourselves, for this afternoon session begins again at 2 o'clock. We'll see you back at 2.